and they're about the application or not of the e-privacy directive in the law enforcement context. Two cases, one from Bulgaria, again, another case from Bulgaria, and a case from Austria. The first case is Spetsializirana prokuratura. Many Bulgarians have to excuse my my pronunciation. The special public prosecutor case from Bulgaria. It's no coincidence this case is about cigarette smuggling. There used to be a huge, I don't know if it's still the case, I used to work on anti-fraud a few years ago, used to be a huge problem of cigarette smuggling, counterfeit in Bulgaria. Olaf used to work with the Bulgarian authorities. So it's good to see they're carrying on the good work of catching contraband. And in this case, it turns on the Bulgarian law and its consistency with EU law, because this was concerned 5 people suspected of tobacco contraband, and the public prosecutor asked the Special Criminal Court for prior authorization access to their traffic data. And that's covered by the Privacy Directive 2002/58, and Article 15 of that directive says that member states can derogate from its provisions and the rights and obligations therein for the purposes inter alia of criminal law enforcement. Now, Bulgarian law requires general and indiscriminate retention of all traffic data for maximum 6 months, to have it available just in case the authorities need it, and permits law enforcement access to such data if there are persons suspected of a serious criminal offence and there has been prior judicial authorization. So that's why the public prosecutor was seeking that authorization. The law doesn't limit access to what is strictly necessary to obtain the objective pursued, but does, according to the case law, require reasonable grounds of suspicion. Now, the Special Criminal Court, the Spetsializirana, I won't attempt to pronounce it either, it was faced with a quandary. As it understood it, Bulgarian law was inconsistent with the case law of the Court of Justice on the interpretation of Article 15 of the In-Privacy Directive, interpreted in line with Article 7, 8, 11, 47 and 52 of the Charter of Fundamental Rights, basically saying you can't have general and indiscriminate retention of all traffic data for criminal law enforcement. But the problem faced by the Special Criminal Court was its own hierarchical judiciary. The Constitutional Court had found the Bulgarian law compatible with the Constitution. It had said that 6 months rather than 12 months is not an excessive retention period. So that's a sort of protection for data subjects. It's just a shorter period. And it felt there was practically no other way of obtaining sufficient information for the purposes of combating serious crime. And to add to this, the Special Criminal Court said, well, there are other safeguards, which are good here. Access is limited to investigation of serious crime. It's subject to prior judicial review, ex ante, and it's subject to supervision by the Data Protection Authority and a parliamentary committee ex post. So the Special Criminal Court said, well, these safeguards may be equal to or even better than the requirements of EU law. So maybe it would be there could be even a balancing factor justifying general data retention. And I think this was rather delicately put, the Court of Justice has not yet had the opportunity to consider the arguments relied upon by the Constitutional Court of these additional safeguards. So it felt it was appropriate to send this case to the Court of Justice. Now, why did the Special Criminal Court start off by thinking there was an inconsistency with the case law of the Court of Justice? Well, if you look, this is just a section of a selection of the case law. The cases in blue are the case law of the Court of Human Rights, the European Court of Rights in Strasbourg. The cases in black are the Court of Justice. The red dots are the cases that were cited in argument by the Special Criminal Court. I would rely actually on Xavier Tracol's excellent introduction to this case law in the first lecture. And I just point out a couple of things about these cases. Malone is interesting because there you saw the very first reference to profiling by the European judiciary. Judge Louis Petiti, in his concurring judgment in that case, talked about profiling and how the authorities increasingly, and this was in the 1980s, are building up a picture of the private lives of citizens using the technology then available. You could fill a couple of screens with the case law of the Court of Human Rights, but I just mentioned four more of them: Zakharov and Jarbo in 2015 and 2016. And I mention those because they show the parallelism between the approach of the Court of Human Rights and the Court of Justice dealing with surveillance and the concepts of proportionality and necessity. And then I mention 2021 rulings of the Court of Human Rights in the Centrum för Rättvisa and Sweden and Big Brother Watch in the UK cases, where the court drew a bright line between its case law and the case law of the European Court of Justice, saying that mass surveillance, or bulk collection, as it's now rather nicely called, is okay so long as there is end-to-end safeguards from the prior authorization right through to ex post supervision and judicial remedies. As opposed to the Court of Justice, in those cases, which has basically developed the principle that where you have profiling going on in mass surveillance, then you cannot have generalized and indiscriminate retention of personal data. That was striking down the Data Retention Directive in 2014, national laws in 2016 in Sweden, in the UK, in the Telecommunications and the Watson case. There was a lot of pressure from member states saying, we really need to be able to do our jobs. So in the Quadrature du Net case, which was then affirmed in the subsequent case law, the court said, well, national security is a bit different, so you can have general and indiscriminate retention, so long as there's what I would call a clear and present danger. That is, where there's a serious threat to national security that proves to be genuine and present or foreseeable. So there is this distinction between the case law of the two courts. But the Special Criminal Court was quite right. There is an inconsistency with the Bulgarian law, and the Court of Justice basically said, yes, we've already decided all this. Generalized indiscriminate data retention is contrary to EU law, la Quadrature du Net. And we have already said that the argument that only such measures of generalized and indiscriminate retention allow us to combat serious crime. We've already rejected that argument in our Angarda Shihona ruling. And again, it's limited the exception for national security. It's limited to national security, not for purposes of combating serious crime. And even short retention periods, in the case law, 10 weeks or 4 weeks, can enable private life to be monitored and profiles to be established in SpaceNet. And they did say, well, look, the supervision of retention by the Data Protection Authority, the Parliamentary Committee, can reduce, but it doesn't eliminate the risks to the private life of monitoring and profiling. And then in a more positive way, the court actually laid down some criteria. It says, if you are giving access, it must be limited to what is strictly necessary, both with regard to the category of the data and the duration of access, in order to satisfy proportionality. People have to be told of their use of their data as soon as the disclosure doesn't compromise the criminal investigation. Otherwise, how do you exercise your data protection rights, particularly the right to judicial remedy? And the right to an effective judicial remedy is not respected by prior judicial authorization, because that doesn't give you ex post facto redress against unlawful access. So a lot of useful criteria in this case. Let me just bring out what I think are the main points. What's first thing that's interesting is this case was of quite low importance to the Court of Justice. The case law is absolutely settled and clear, includes something I haven't mentioned, which is in the Ministerio Fiscal and the Prokuratura case, the distinction between an exception to scope, the EU legislation and the treaty itself doesn't apply to national security or sovereign activity with regard to criminal investigations. I mean, the GDPR in the second case, things like the GDPR and the Privacy Directive, as opposed to the derogation in Article 15 of the e-Privacy Directive in the GDPR, in the LED, where, well, so in the LED, of course, the derogation says it applies where the law enforcement or intelligence authorities access data that has been collected by telephone companies or internet service providers. That has been already collected, and there the rules apply, and the derogation permits access and processing of that data. So the law was absolutely clear. There was a judgment by a chamber, not the Grand Chamber, whereas all those cases in that previous slide were done by the Grand Chamber. There was no Advocate General opinion felt necessary to discuss the case law. It's very clear. There was no press release, and there aren't even any translations from the original language, Bulgarian, except into the working language of the court. So clear, they didn't think it was that important. And they just felt they had to repeat what the issues were. But it's of high importance to the national court, which referred the case, and to the member states generally. I mean, the Special Criminal Court was faced with a conflict between the jurisprudence of its own constitutional court and that of the Court of Justice. So it's really important for it to be able to get some clarity as to how to apply the law in this case. And again, there were 7 member states which intervened, so they all piled in. They thought it was really important. The points being, they're always hoping that the court will soften its case law in this area. I'll just make 2 last points on this case. A month before the decision to refer the case, the Court of Human Rights laid down its new approach in Centrum for Rotvisa, Big Brother Watch. And there's a sort of balanced approach, you might say, this end-to-end safeguards, where if everything overall is okay, it doesn't matter if there's something missing. For example, notification was missing in the Swedish case, was never done. And that might have helped the Special Criminal Court. And indeed, if they'd included arguments based on that, who knows, it might have gone back to the Grand Chamber. But they didn't. And this is perhaps, for me, the big takeaway from this case, which has nothing to do with the Privacy Directive or proportionality. It's the fact that it was done by the first instance court. So this avoids delay during the appeals process. You know, this previous case we just heard about, where there was the case started in 2013, and there was civil litigation for excessive duration. You can avoid that if you are the first instance court and you use your right under Article 267 of the treaty to refer to the Court of Justice. And there was 17 months between the lodging of this reference and the ruling. So it just added that period. And at that point, the National Court was ready to apply the law. And I compare it with a case, perhaps one of the most important cases on the definition of controller and joint controller under the GDPR, the Wirtschaftsakademie case, where it took 11 years from the decision of the Data Protection Authority banning the Business Academy using a Facebook page to actually a national court applying that ruling, it having been up and down the internal appeals procedure and to the Court of Justice and back. So I would strongly underline that the importance of the fact it was done by the the first instance court. Let's move to the next case, Bezirkshauptmannschaft Landeck from Austria. This concerned a German citizen who lived and worked in Austria, and somebody sent him or her a package with 85 grams of cannabis. And this was intercepted by the customs, and they were obviously interested now in this person. Why are people sending you 85 grams of cannabis? I mean, this isn't a big dealer, but 85 grams is a lot for personal use. I mean, this is, I assume, there may be experts on this about, but anyway, it looks to me as if this was possibly, they suspected this person of being a small dealer, I think. And so they actually visited the person in the person's home and seized the person's GSM, the mobile phone, and invited that person to open it for them so they could see all the other good stuff in the phone that might help establish whether this was being criminal activity going on. That person refused. They took it away, and for 7 weeks locally, and then in the central criminal office in the federal office in Vienna, they tried to access it. They couldn't break in. And in the meantime, the plaintiff had, or the suspect, I want to call him or her, had gone to court to sue for restoration, for illegal processing and restoration of the telephone. So they got it back after 7 weeks. And the Landesverwaltungsgericht Tirol, again, another first instance court, referred a number of questions to the Court of Justice, and it referred them on the basis of the Privacy Directive. Why? Well, all the cases that you see, and it was quite a scholarly reference, are all based on the Privacy Directive and Article 15 and proportionality and so on. And the trouble is that this case is not actually about the e-privacy directive. And this is pointed out by the Advocate General. And I think this is why, Magda, you chose this case, even though it's only the Advocate General so far, because the Advocate General pointed out that this concerned the LED, Directive 2016-680, because, and this is here in the case law of the Court of Justice, that if there is no access to what you might call private data, access to a telephone company or to a internet service provider, if the public authorities are doing it themselves as an act of sovereign enforcement, then the e-privacy directive doesn't apply because there's no interference with communications, and the e-privacy directive is about protection of communications. So the Court of Justice actually wrote back to the National Court and said, have you thought about the LED? And the National Court basically provided no details. They said, well, of course, yes, we'll apply that too, if necessary. But they didn't do any more. And the Advocate General thinks most strongly that the Court of Justice is not obliged to rewrite the reference if the National Court can't be bothered to do it. And I think the Advocate General is a bit worried because the Court of Justice actually wrote to the parties before the hearing and said it would be grateful if they would address their arguments on the basis of the application of the LED rather than the e-privacy directive, in case it wanted to reformulate the questions and answer it, sending it back. So the Advocate General is saying most strongly to the Court of Justice, don't bother replying to this. The National Court did not make the effort to get back to you and reformulate its questions. It's not for you to have to do it. And it said, that there is actually it's cooperation between the National Court and the Court of Justice. It's very precious. It makes our system work, but it has to be two-way. So the National Court has to make it very clear what is the legislation concerned, what are the relevant facts, and what are the arguments and issues, so that the court can make a specific decision. There were other, shall we say, grey areas in this case. That was the police action lawful or unlawful? And Austria simply admitted that, well, actually it was unlawful. So the Advocate General thinks that the reference was moot anyway. There's the case law again, just so that you know which were the cases cited. And I think the case that shall we say, misled the National Court was Ministerio Fiscal, because that was about a mobile phone, and it had been basically it had been stolen, hadn't been seized by the police, and it was the investigation to find the thief. And so the National Court, asked Court of Justice, is it okay to ask the telephone and the company for who the details of the person who accessed that telephone for a period of 12 days after it had been stolen, so they could find out who had stolen it. But of course, although it was just a little phone, it wasn't the phone that was at issue. It was accessing data that had been retained by the telephone company. So the e-privacy directive applied in that case. But this is not the case here. This is actually accessing or failing to access the phone itself. So I think, there were grounds for getting this wrong, but which you can see in the case law. Now, the Advocate General said obiter, well, he thought it would have been admissible concerning the LED if the question had been asked, because even though there'd been no actual processing, there had been an attempted access. They'd failed to get in, but they'd certainly tried. So he felt that if the case had been brought under the law enforcement directive, yes, it would have applied, even though there had actually been no processing as such. And then he said, well, look, in case the court does decide to make a ruling in this case, I'm just going to tell you what I think about the substance. And the first, and he answered three questions he posed by the National Court. And the first question is basically about the fact that there was profiling going on, and how far the LED directive applied in, is this a serious or is it a minor case? Firstly, he said, well, the LED is not limited to combating serious crime. It covers all sorts of crimes. And that includes access to a mobile phone to investigate an ordinary crime, which is this possible dealership in cannabis. But the access to the phone data may reveal an awful lot more aspects of the owner's private life. And therefore, it's interesting. He said, you have to interpret the law enforcement directive to say that it requires that the processing of the phone data must be limited to what's necessary for the investigation. Or it may even be necessary to say, well, we don't authorize it where it's a very trivial offense, or has very little evidential value. It's this balancing that the previous speaker was talking about, where you're looking at the scope of the interference, which is great because it's profiling, and the actual offense concerned. So if it's profiling combined with a minor offense, you basically shouldn't be processing the data. Second question, what about the lack of prior judicial authorization or by an independent authority? The Advocate General, it's another murky aspect of this case, wasn't sure whether national search and seizure law required a prior authorization. But in any event, he looked at the law enforcement directive and he said, well, it doesn't require prior authorization anyway. But because of the profiling, because access to phone metadata can permit it, then you interpret in the light of Articles 7 and 8 of the Charter, and you say that prior authorization is required. And he based that on the prokuratura case. And I'm going to talk about Riley in California in a moment. And then question 3, what about the notification of the data subject? And he said that there's this distinction here. The data subject knew the police had seized the phone, but not that they tried to access it. Well, that's true in formal terms, but I wonder what the data subject thought that the police were doing with it for 7 weeks, if not trying to access it. But they didn't tell him. And the LED, as the GDPR, permits transparency obligations to be delayed until the transparency would no longer be a problem for the investigation. But he said, in any event, the lawfulness of the attempted processing isn't dependent on respect for transparency. It's whether it's lawful in itself. And there, with the greatest respect, and that's when an Englishman says with the greatest respect, you realize that he or she is disagreeing with you. In another case, which you're going to be talking about on Friday, I think, Pankey, that was one of 3 cases, all decided this year, which stressed, yes, it's a procedural obligation, the obligation to respond to an access request, but it's very important. And it's part of transparency, Article 12 of the GDPR and so on. So I'm not sure about that last point, and you may like to think about it when you're talking about Pankey on Friday. So is there anything we get from this case? Well, the first thing is, if you are settling your reference order and you're a national court, then, get it right, follow the rules of procedure of the court, set down what the legislation is, and put in everything that the Court of Justice needs so it can give you a good opinion. And this is what this case adds, if the court gives you a big hint that actually it's about something different, then please reword the reference correctly. So that was the, I don't think the National Court really understood what the court was saying, the Court of Justice was saying when it wrote back about the Data Protection Directive. So get the reference order right. Then about the Law Enforcement Directive, I say broad scope of processing includes attempts to gain access to the data. The fact that the Law Enforcement Directive applies where the police directly carry out the processing, there's no telecoms company or internet service provider involved. And the investigation of minor crimes must respect necessity and proportionality in light of the Charter. And also in light of the Charter, you have to have prior judicial or independent administrative authorization required for the search of a mobile phone. And then the last point, and this goes right back to Malone in 1984. It reflects comments by the President of the Court of Justice in 2019 at the conference of the Global Privacy Assembly, 2018, where he said that profiling is of massive interest to the court. When that takes place, the court will look very closely at the legislation and the behavior involved, because it is such a massive invasion of privacy and data protection. And the best way of understanding that, you will see it repeated and repeated in the case law. But if I actually finish by talking about Riley in California for a moment, it's a judgment of the Supreme Court of the United States, June 2015. And that was where the police had seized a mobile phone as part of an investigation of a drive-by killing. And they seized it and accessed it. They managed to access it in the same way that they would have seized a wallet. And under the Fourth Amendment, it's okay if you're search and seizure in US common law, you can open a wallet and see what's inside it. Does the same apply to a mobile phone? The Supreme Court said almost unanimously, so included all the conservative judges as well. It said, no, it's a much bigger invasion of privacy if you open up the contents of a mobile phone. There's what's on it, which is, shows all the people you've been talking to and what they and so on. B, there's what's not on it. It's where you've been looking and what the messages are that you've been sending. They said, the Supreme Court said that the mobile phone constitutes a digital record of nearly every aspect of our lives. Modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. So I would just end with that anything that involves searching a mobile phone or checking on phone records is regarded as extremely serious and an infringement of privacy under Article 7 of the Charter and Article 8. So with that, just to finish this last slide, if you're interested in this thing that the National Court could have done in terms of a balancing approach, I wrote an article with my American counterpart when we were doing negotiations on data protection and PNR on how you might use accountability to provide a sort of balanced approach that might be acceptable to the Court of Justice. So I finish with that postscript. Thank you, Magda.